Okay, we'll get started. So if you haven't already done so, please type your name into the chat so you'll get credit for attending. And welcome to our final session on New York State specific benefits. We're talking about workers' compensation today. And I tried to think of a story that would be appropriate for a workers' compensation training, and then I remembered it. So I used to live in Baltimore, which has a suburb called Overlea, Overlea, pronounced Overlea. And there was a supermarket in Overlea that closed. And oddly enough, the building was bought by a medical practice that specialized in workers' compensation claims, and they used it for their office spaces. But even odder was the name they chose for the practice, which they proudly announced on a sign on the front of the building. And it read, Overly Personal Physicians. And you would have thought that somebody would have said, uh, maybe not. But needless to say, they went out of business within a year. So, workers' compensation is another benefit that exists in every state, but is different in every state. And we've got just three objectives for today's training to consider who's eligible for workers' compensation and how to apply. Applying is called filing a claim, same as for unemployment insurance. To talk about the kinds of workers' compensation cash benefits that an injured worker may receive, and how to calculate the benefit amounts. Not very complicated. And then finally, to look at how workers' compensation benefits, the cash benefits, interact with SSI and Social Security disability benefits. So the purpose of workers' compensation is to provide some assistance to workers who have been injured in accidental job-related injuries or have acquired occupational illnesses through work. And workers' compensation provides several kinds of assistance. First of all, partial replacement of lost wages. So that's in that regard, they're similar to unemployment insurance. Um, it covers medical expenses related to the accidental job-related injury or occupational illness for a lifetime, unless the worker has signed a waiver as part of a settlement that excuses the workers' compensation insurer from having to pay for any further medical expenses. For workers who need to be retrained for a different job because the injury makes it impossible for them to continue their original job, it provides vocational rehabilitation and social work services. And for workers whose injuries or occupational illnesses result in death, it does provide cash benefits for survivors and covers funeral expenses for the deceased worker. Okay. So who is eligible? Workers in for-profit businesses that have at least one employee all have to be covered by workers' compensation insurance. And most workers in nonprofit agencies also have to be covered. There are some exceptions, particularly clergy and teachers. However, let me point out that sometimes, even if it's not required by law that a worker be covered by workers' compensation insurance, their employer may choose to cover them anyway, such as clergy. So even if it may not be mandatory that a worker is covered, if they become injured on the job or are diagnosed with an occupational disease, they should go ahead and file a claim in case they may be covered. So to be eligible, the worker has to have been injured or sustained an occupational illness uh, in the course of work, except the injury can't be caused solely by intoxication from drugs or alcohol, or caused by the intent to harm oneself or others. The worker has to be unable to work for over 7 days in order to get lost wage benefits, and they'll only get paid for the first 7 days of non-work if the disability lasts for more than 14 days. This part seems fairly fair if the worker continues to get wages paid, full wages paid by their employer for a period of time after the injury or illness. Then if they have received workers' compensation cash benefits during a period of time when they were still getting wages from the employer, then they may need to pay back the wages to the employer that they had received. It would essentially be double dipping. Or I'm sorry, I misstated that. They'd have to pay back the workers' compensation cash benefit, the lost wages benefit, for the period of time when they were getting the wages. Remember, the lost wages benefit provide only partial compensation for the wages, not full wages. So if they're getting the full wages, they'd rather have those than the lost wage benefits during a period of time. However, if once the wages stop, then the lost wages benefits can continue, although they will be less than the full wages the worker had received before the injury. So there are a number of types of workers for whom workers' compensation coverage is not required by law. Sole proprietors, members of limited liability partnerships are not required by law to be covered by workers' compensation, but they can choose to be covered anyway. Some part-time domestic employees, independent contractors. So a lot of self-employed people don't have to be covered. Realtors, brokers, hairdressers who rent booths. Not sure what kind of horse trading went on to come up with that specific one. But as I said before, the worker is injured on the job, they should go ahead and file a claim because they may be covered, even if it's not required by law. Let me also mention that generally, an employer will pay for a private company, a private insurer, to cover the workers' compensation. They pay insurance premiums to be covered by a workers' compensation insurer, a private one. However, there are some employers who may choose to self-insure. So they're generally larger ones that won't hire a separate company. They'll handle their own workers' compensation insurance in-house. So how do you apply or file a claim? First, you have to notify the employer as soon as possible, but not more than 30 days after the incident. So after the accident or after becoming aware of the occupational illness. Sorry. Also want to report to the New York Workers' Compensation Board as soon as possible. but not more than 2 years after the incident. There is a form, employee claim form C3, and that can be filed online using the link at the bottom of slide 8. Or the form can be downloaded using the first link on slide 9 and completed and mailed or emailed to the board. There are instructions with the second link on slide 9, or the worker can visit the nearest office of the board, and those appear on the third link, slide 9. Now, sometimes if a worker files a claim, there may be a dispute. The employer may dispute that this was in fact a work-related injury or illness, and the worker may need to view their case file to look at the evidence that was used or is being used to make a decision. And they can get access to that online using the link on slide 10. There is an advocate for injured workers who can help workers who are filing claims and may be having difficulties. And their information is on slide 11. I'm going to pause for a moment, see if there are any questions. Okay. Pamela asks, so you have to file both to the employer and the board. Yes, you do need to file to both. And frankly, Pamela, I think it's a good idea to file to both. That way the employer is on notice that you filed, but you're not relying solely on the employer to report it. What if you've got an unethical employer who doesn't want to acknowledge that you filed a claim? They could claim they never received the report. So it's good to have the workers' compensation board as the backup to make sure that it's clearly understood that you did file the claim. But good question. Thank you. Any other questions before we move on? Okay. Now, there is a kind of cash benefit that workers may receive if they have a disputed claim. So the employer or the employer's workers' compensation insurer is disputing the claim, perhaps saying that the injury or illness was not work-related, or maybe that the injury or illness was not as severe as the worker is claiming it was. If that claim is disputed, and so it may take longer for it to be decided whether the worker is going to get workers' comp, then the worker can ask for short-term disability benefits, which is different from workers' compensation. And they can use a notice and proof for claim for disability benefits form that's linked at the bottom of slide 12 to request the short-term disability claim, basically to get some cash benefit while they're waiting for the workers' compensation claim to be processed and decided on. But the disability benefits don't pay much. You only pay $170 a week maximum. So it's kind of a booby prize of benefits. That's what you can get. So you've got at least some money coming in while waiting for the workers' compensation claim to be filed. Now, short-term disability claims can also be filed for workers who become unable to work due to a condition which can include pregnancy, obviously pregnancy with complications, that was not work related. So, so that's why you could file the short-term disability claim if the workers' comp claim was being disputed by the employer or the employer's insurer, as being, whether it was in fact work related. And there's more information about the short-term disability benefits at the link on slide 13. All right, let's get into the lost wages benefits, which are also called indemnity benefit and death benefits. So the benefit amount and how it's calculated will differ by the different types of benefits. The minimum benefit in New York currently is $325 a week. The maximum benefit is the average state weekly wage for the prior year. And that was just updated, and I just made the updates on this PowerPoint. So the information that you've got here in this PowerPoint is effective as of July 1st, as of next Tuesday. And it'll be current for the following year until June 30th of next year. So the maximum benefit currently is the average state weekly wage last year, which was $1,222.42 per week. Note that workers' compensation benefits, like unemployment insurance benefits, are paid weekly rather than monthly. And the minimum and maximum benefit amounts are set to the date of the incident, to the accident or the accidental injury or the diagnosis of occupational illness, and they don't change over time. So in other words, there's not going to be a benefit increase each year for workers' compensation. The amount will stay the same. So the different kinds of lost wage benefits have very descriptive names. I like them for that, because if you read the name, you pretty much know a good description of the illness or the injury. First one is temporary total disability. So obviously what that would indicate is that the injury or occupational illness is for a short term, making it impossible for the worker to work at all. And temporary total disability benefits pay 2/3 of the average gross wage the worker received during the year before they filed the claim, multiplied by a disability percentage that's set by a workers' compensation judge. And it can be 25, 50, 75, or 100%, depending on the severity of the disability and how much it's expected to affect the worker's ability to work. And that's the formula you use, but it's capped. The maximum benefit is, once again, that average state weekly wage of $1,222.42 a week for any claim that's filed between July 1st next week and June 30th next year. So the percentage of disability actually has to be reviewed by treating healthcare providers every 90 days and approved by a workers' compensation judge generally. And the temporary total disability benefits can continue until the worker is able to return to some type of work, even in a limited capacity. And then they would switch to a different kind of benefit, and you can probably guess the name of that benefit. In fact, it's called temporary partial disability benefits, meaning it for a short period or a relatively short period, the worker is able to work, but not as productively as they were before the injury or illness. And the amount of that benefit, just like with temporary total disability, is 2/3 of the average gross wage in the year before the injury or illness, multiplied by the disability percentage, and it's got the same maximum payment. When a worker is receiving temporary partial disability benefits, they are required to do a work search and continue searching for work until they find it. Although it may not necessarily be full-time work or work at the same earnings level they had before the injury or illness, since their workability is going to be limited. Next is called reduced earnings benefits. That is essentially temporary partial benefits for workers who have returned to work. So they can continue to get benefits if they're temporarily unable to work at full capacity, but they do return to work in at least a limited capacity. And to calculate the amount of that benefit, you take 2/3 of the difference between their earnings before the injury and their limited earnings during the period of injury. So it's 2/3 of the difference between the before and after wages. And the maximum benefit is the same as for the other types. So, so a worker who's getting either temporary partial or permanent partial disability benefits, we'll be talking about permanent partial momentarily, and then returns to limited work, is going to be switched from temporary partial or permanent partial disability benefits to reduced earnings benefits. But if the worker stops working, other than voluntarily, they will then be returned to temporary partial or permanent partial disability benefits. Next, as you would have predicted, permanent total disability benefits, meaning the injury or illness prevents the worker from working at all, and that's expected to be long-term. And it just like with the temporary total and temporary partial disability benefits, it pays 2/3 of the worker's average gross wage, although that's not multiplied by a disability percentage. It's assumed to be 100%. And the maximum, once again, is the average wage for the state. That benefit can be paid indefinitely. Then there's permanent partial disability benefits. So the injury or illness is expected to limit the worker's ability to work, but not prevent them from working on a permanent basis. And permanent partial disability benefits are divided into two kinds. There's called schedule loss of use, which provides higher payments for certain permanent injuries that usually involve injury to particular body parts. We'll get to that in a moment. And then non-schedule loss benefits that provide lesser payment amounts than the schedule loss of use benefits. So to get schedule loss of use benefits, the higher paying ones, these are paid for permanent loss of certain body parts, like part or all of arms or legs, or eyesight or hearing. And the duration of the benefit, the length of period you can get it, depends on the body part and the severity of the disability. So the amounts can vary. And for the non-schedule loss benefits, for injuries that occurred before March 13th of 2007, there's no limit to how long those benefits can continue. If the injury occurred after that date, then the period that the benefits can be paid is going to be limited. Now, once the worker reaches maximum medical improvement, so they've gotten treatment, gotten medical care, and the medical treatment is no longer helping. It's no longer alleviating the disability and making them more able to work. Then a hearing is held, and a workers' compensation judge makes an award, a cash award, that they'll get in a lump sum generally based on the loss of their wage earning capacity, the amount that disability on a continuing basis is expected to limit their ability to earn wages. And for non-schedule losses, the limit on how long they can be paid can range from a minimum of 4 years and 17 weeks if the earning capacity was reduced by 5 to 15%. And on the high end, it's up to 10 years and 5 weeks if earning capacity was reduced by 95 to 99%. And as you would imagine, for earning capacity being reduced by more than 15%, but less than 95%, the length of time you can get that benefit is going to fall between 4 years and 17 weeks and 10 years and 5 weeks. So the permanent partial disability benefits, like the temporary partial and temporary total disability benefits, pay 2/3 of the worker's average gross wage before the injury or illness multiplied by their disability percentage, and it's got the same maximum benefit amount. So if a worker's getting permanent partial disability benefits and then their health condition deteriorates, maybe they have an occupational illness that progresses and they can no longer work at all, they could then file for permanent total disability benefits. There is an additional cash benefit of $20,000 or up to $20,000 for permanent disfigurement of face, head, or neck. I know some of these sound a bit gruesome. And then there are death benefits for survivors of a worker whose injury or illness resulted in death. And their surviving spouse, surviving minor children, and other dependents can get cash benefits after the death of the worker. And those pay, divided among all the survivors, 2/3 of the worker's average gross wage in the year before the injury or illness, up to the maximum $1,222.42 a week. And so that amount is divided among any of the survivors. If there are no survivors who are eligible for cash death benefits, then the worker's estate can get up to $50,000. And death benefits also pay for memorial and funeral expenses, up to $10,500 in most counties and up to $12,500 in some other counties. Okay, before we go into some examples, just want to pause, see if anyone has any questions or comments so far. Okay. Move ahead now. So I did email you. Actually emailed you twice this PowerPoint. If you don't have the PowerPoint open, this would be a good time to open it. Because we're going to go through some examples of workers who qualify for different lost wages benefits, and you're going to be calculating or just determining which type of benefit they should get and the benefit amount they should receive. So it's going to be helpful if you've got access to the PowerPoint. You can go back through the slides to determine how to calculate the benefit amount. So first example is Latoya was injured on the job. She's expected to be unable to work at all for several months. Her average gross wage before her injury was $600 a week. Her disability percentage is 100%. So, two questions for you. Which kind of workers' comp benefit should she receive? You can probably figure that one out without having to look back at the slides. And second part of the question is, how much should her benefit amount be? And if you can look that up and then type your answers into the chat, that would be great. Okay, so we seem to have universal agreement on temporary total disability benefits and $400 a week. And that's correct. The disability is only expected uh, to limit her ability to work for several months, so it's temporary. Um, but she will be unable to work at all during that period, so it's temporary total. And the benefit amount is two-thirds of her average gross wage before the injury multiplied by the disability percentage. So two-thirds of 600 is 400 times 100% is 400 a week. Okay. So it's not too complicated. Right. Moving on. Jacques was injured on the job. He's not expected to be able to work at all permanently. His average gross wage before his injury was $900 a week. Which kind of workers' comp benefit should he receive, and how much should his benefit amount be? Hey, we're getting permanent total, $600 a week. That is correct. Um, So to calculate permanent total, you don't need a disability percentage rating. It's assumed that it's 100%. So you just take the $900 gross wage before the injury, multiply it by 2/3. That's 600. That's less than the maximum $1,222.42 a week. So that's the benefit that Jacques would get. And Dawn commented, yes, but the insurer, the employer is sure to fight Jacques on that and dispute that he should be getting permanent total. And that may be the case. That's why there are many workers' compensation lawyers out there to represent injured workers in workers' compensation claims. Right, next, Angelina was injured on the job. The injury is expected to limit her work ability, but not prevent her from working for at least 5 years. Her average gross wage before the injury was $1,200 a week, and her disability is rated at 50%. So, which kind of workers' comp benefit should she get, and how much should her benefit amount be? Yes, take about 10 more seconds. Okay, we had uniform agreement on $400 a week, which is correct. And most of you answered permanent partial. Some of you answered temporary partial because I think that you were using the common understanding of the terms permanent and temporary. Um, in fact, the term permanent um, would probably be better replaced by the term long term. Somebody whose injury was expected to prevent work for 5 years is going to generally qualify for permanent disability benefits, even though 5 years is not the customary definition of permanent. Um, so to calculate the benefit amount, again, you take 2/3 of the before injury wage, 2/3 of $1,200 a week is 800 a week, and then multiply that by the disability percentage of 50%, and that gives you 400 a week. Next is Ben, who's injured on the job. He's expected to be able to do only light duty for several months. Before his injury, his average gross wage was $1,200 a week. His disability is rated at 75%. So, which kind of workers' comp benefit should he receive, and how much should his benefit amount be? Yeah, I think we've got uniform agreement on $600. We've got some disagreement about the type of benefit. It is, in fact, temporary partial. Temporary partial you can get if you're not yet working, if you have not returned to work. So Ben has been injured. He's got a temporary disability is expected to limit his ability to work, but not prevent him from working for a temporary period. So it's temporary partial. Um, in a lot of states, they don't have a separate benefit that's called reduced earnings. In New York, they do. I think it's actually helpful because reduced earnings you would get only if you were partially disabled and then you've returned to work. But Ben has not yet returned to work, so he can get temporary partial benefits, which means for a temporary period, his workability is limited, and you calculated his benefit correctly at $600 a week, but he has not yet returned to work. If Ben goes back to work, then he could switch to reduced earnings benefits. So to get reduced earnings, you have to be working. You have to return to uh, limited work, earning less than you did before the injury. Okay, that's the distinction. There's a question in the chat about what's the dividing line between temporary and permanent. That's a great question, and I don't know the answer. I don't know if there is a hard and fast um, time period during that the disability is expected to prevent work or limit work that marks the dividing line between temporary and permanent. But I think that's something that a workers' compensation judge would decide when the claim is being disputed. Okay. Um, okay, so some people did not get the email that I sent yesterday. Marilyn, thank you so much once again for sending these out. I really appreciate it. Um, Apparently, I did not have a complete list. I kept adding people to the list each training, but wonderful. I'm going to give people a moment then, if you've just received the PowerPoint, to go ahead, retrieve it, and open it so you'll have it available. But just to repeat that point once again, if someone is partially disabled, um, temporary or permanent, their workability is limited, but they're not prevented from working, then they're going to get, temporary or permanent partial disability benefits once they return to actual work in a limited capacity, earning less than they were before the injury or illness. Then they'll be switched to reduced earnings benefits. That's the distinction. Okay. Right. So I've kind of given away the answer to the next one. Ben returns to work and receives $300 a week average gross wages. His average gross wage at the time of his injury, once again, was $1,200 a week. So, which kind of workers' comp benefit should he get now, and how much should the benefit amount be? We got three answers, but sure more of you can weigh in on this. And looks like I've already skipped ahead to the answer inadvertently. Or no, I'm sorry, I went backwards. There we go. Okay. Okay, so I think we've got agreement on reduced earnings benefit after my repeated explanation there. And the benefit amount is 2/3 of the difference before and after wages. Um, and that would be 2/3 of $900, which is $600 a week. Great. So not too complicated to calculate the amount of workers' compensation cash benefits, particularly if the before and after earnings amounts are nice round numbers that can easily be multiplied by 2/3. So oftentimes, rather than getting weekly cash benefits, during a workers' compensation claim, a settlement will be reached. And a settlement results in a single payment, generally in a lump sum, that will close the case, that will say, okay, we're giving you X amount. If you agree to this, then that will close out the claim. You will not get weekly benefits. And if the settlement includes medical benefits, then you won't get any further payment for medical benefits either. So the settlement could close out the claim for cash benefits, also known as indemnity or lost wages benefits, or medical benefits, or both. That's going to be part of the negotiation for the settlement. Settlements are optional. Both the worker and the insurer or the employer need to agree mutually. The Workers' Compensation Board will review and either approve or reject a settlement, but they don't negotiate. They don't act as like an arbitrator. And once a settlement is signed and approved by the Workers' Compensation Board, that's the end of the claim. The worker can't reopen it later. So there is a certain amount of risk to entering into a settlement because it means it's permanent. And let's say, the worker discovered later that the disability was more severe than they thought or more long lasting. If they have already entered into a settlement, it's too late to go back and renegotiate it. Nonetheless, settlements are common. Workers' compensation benefits are not taxable. Might recall that unemployment insurance is taxable. Workers' compensation benefits are not taxable. So you can get them and not have to worry about owing taxes at the end of the year. So sometimes a third party will be found liable for an injury or an illness. So the injured worker may sue some other party other than the employer as being responsible for the injury or illness. Maybe unbeknownst to the employer, there was some chemical spill or something caused by a company that's in a building next door to where the worker was working. And that chemical spill resulted in the worker's injury or illness. And so that company that was responsible for the spill is found liable for the injury or illness, and there's a lawsuit. Generally, the proceeds from the lawsuit are going to go, at least partly, to reimburse the employer or the insurer for benefits that were paid to the injured worker, particularly if it's a large settlement and it's more than enough to reimburse the workers' compensation benefits. But there is an exception under something interesting only in New York, something called the scaffold law. If the injury resulted from a fall from a scaffold or other elevated structure, then the scaffold law will apply and the worker can keep the workers' compensation benefits and the settlement amount from the lawsuit. We're going to pause for a moment for questions or comments before we talk about how workers' comp interacts with SSI and Medicaid, and then Social Security, disability, and Medicare. Any questions, comments so far? All right. So the way that workers' compensation interacts with SSI and Medicaid is basically the same way that unemployment insurance interacts with SSI and Medicaid. Workers' compensation cash benefits, the indemnity or lost wages benefits, are considered unearned income, and they will reduce SSI payments accordingly. If you remember your SSI calculation, you'll know that you take unearned income, you subtract $20 a month from it. The remaining amount is the countable unearned income, and you subtract that from the maximum SSI that you could get if you had no countable income. Okay, so very simple. So workers' compensation benefits will reduce SSI almost dollar for dollar. You subtract $20 from the workers' comp, all of the rest is countable unearned income and is subtracted from the SSI maximum benefit. So if the workers' compensation benefit is high enough, the SSI payment will be reduced to zero. It will be suspended. And those of you who remember your SSI rules will know that if SSI stops for financial reasons, due to too much income or too much resources, it is only suspended, not terminated, for up to 12 consecutive months. But if the workers' comp benefit was high enough and lasted over a year, once the worker had been ineligible for the SSI due to the workers' comp benefit for 12 consecutive months, then their SSI would be terminated. But once the SSI payment is suspended, even before it's terminated, Medicaid will stop. But there may be a way that the worker can keep Medicaid. They could either get it back through a spend down, or if they can do at least some paid work, if they've got a partial disability or they've returned to some work and they're getting reduced earnings benefits. If they can return to at least a limited amount of work, then they may qualify for the Medicaid buy-in for employed persons with disabilities, MBI EPD. So having the SSI payments stop due to workers' compensation benefits will stop the SSI-based Medicaid, but there may be another way that the worker can get Medicaid back. So let's do a couple of examples. Kim receives SSI. She was working, was injured on the job, unable to return to work. If she had no other income but SSI, she'd be getting the maximum SSI benefit for an unmarried individual, 1,054 a month. She's approved for workers' compensation, gets temporary total disability payments of $180 a week or $780 a month on the average. So on average, how much SSI should Kim get? And what will her total average monthly income be? Okay, so remember that $780 a month is unearned income. And if you've got your SSI calculation sheet handy, this would be a good time to use it. 780 unearned income. If you want to do it manually, you can take the unearned income, subtract 20. The remaining amount is the countable income, and you subtract the countable income from the 1,054 maximum SSI. And that will tell you the amount of SSI that Kim should get while receiving 780 a month from workers' comp. And then to figure out her total average monthly income, you'll add the workers' comp plus the reduced amount of SSI. Okay, and remember, it gets confusing sometimes because workers' comp benefits are paid weekly, but SSI benefits are paid monthly. So when I said that Kim was getting $180 a week from workers' comp, and then I converted that to a monthly amount, 780 a month, it's the 780 a month that you're going to be using to calculate the amount of SSI rather than the 180. Okay, give you another 10 seconds. Answer if you haven't already. Right. So correct answer is $294 a month SSI. You take the 1,054, subtract the countable income of 760. 780 unearned income minus 20 is 760. 1,054 minus 760 is 294. And then Kim would have 780 a month average workers' comp and 294 a month average SSI for a total of 1,074 a month. And that's what you would expect if somebody gets unearned income that's low enough to receive some SSI. Then when you add their unearned income plus their reduced SSI, the total should generally be $20 more than the maximum SSI. Maximum SSI is 1,054. Kim's total income would be $20 more than that, 1,074. So that works out correctly. All right, next, let's see. Is anything else in the chat? Any questions? Okay. Thank you, Christopher. Okay. So now Slim gets SSI, was working until he was injured on the job. If he had no other income but SSI, he would be eligible for the full 1,054 a month SSI. He's temporarily unable to work at all, and he's approved for workers' compensation, gets temporary total disability payments of $325 a week, which averages out to $1,408 a month. And you want to figure out on average how much SSI should Slim receive and what will happen to his Medicaid. Incidentally, Christopher, I'm not sure if the SSI calculation um, you provided the link for uses the $1,054 a month benefit, or if it goes by um, the excuse me, the federal benefit rate, which is only 967 a month. In earlier training, I had provided an SSI calculation for New York based on 1,054. Okay. Yeah, I'm sorry. I should have sent out that SSI calculator again. But so far, the math has not been complicated, at least. Okay. Another 10 seconds. Right. So, in fact, Slim's SSI would be reduced to zero because his countable income would be more than the maximum SSI of 1,054 a month. So his Medicaid would stop, at least his SSI based Medicaid. But as some of you said, he may have another way to get Medicaid back through a spend down, or if he went back to work, he could use MBI EPD. Okay. Now, a few months later, Slim recovers enough to resume part time work. He's switched from temporary total disability payments to reduced earnings payments. Before he was injured, his average weekly wage was $450 a week. When he returns to work, he earns $375 a week, which would be an average of $1,625 a month. So let's take these questions one at a time. How much should Slim's reduced earnings payments be? And why don't you do this one on a weekly basis? The math will be much easier to begin with. And you can look it up. What's the formula for calculating the reduced earnings benefit amount? So right now we're answering only how much should Slim's reduced earnings payments be? And we're going to figure that out on a weekly basis. Okay, so the most common answer, most popular one was $50 a week, which is correct. The formula for figuring out reduced earnings benefits is two-thirds of the difference between the before and after wages. So before wages were 450 a week, the after wages 375 a week. The difference between those two is 75 a week. Two-thirds of 75 a week is $50 a week. Okay. Next question, on average, how much SSI should Slim receive? And let me help you out with that. So you're definitely going to want to use an SSI calculator for this. If you don't have one, then you can take a pass on this unless you want to try the math. Um, but now we've got Slim receiving $50 a week of reduced earnings benefits, which would average out to $217 a month. Plus, Slim has $1,625 a month average gross wages. So to do this SSI calculation, you'll have unearned income of $217 a month. That's the workers' comp, the reduced earnings benefit, and earned income of $1,625 a month, the gross wages he's earning now. And that should tell you, if you use the SSI calculator, how much his SSI should be now. Okay, give it another 10 seconds.
Michael, where did you get the $217 from instead of the 200 if it's $50 a week? Just curious.
Yeah, that's a great, fair question. Um, we're looking here at average amounts. Um, and with SSI, the payments are actually based on when income is received rather than when it's earned or rather than average. But I wanted to use averages here because the number of workers' compensation payments or the number of paychecks a person may get may differ from one week to the next. If they're paid weekly, they may get 4 weeks of pay or workers' comp payments some months, 5 payments other months. Um, if their wages are paid every 2 weeks, most months they'll get two paychecks. Some months they'll get three. So I figured out, let's just look at averages here. Um, and to figure out Slim's average weekly, or excuse me, average monthly amounts, I took the weekly amount and multiplied it by 4 1/3 because there are 4 1/3 weeks in an average month. So I'm sorry I didn't explain that earlier. Now, in reality, if you were figuring out Slim's actual SSI benefit month to month, you'd have to know how many paychecks did he get in the month, how much pay did he actually receive in the month, and how many workers' compensation reduced earnings payments did he get in that month, and how much were those? and you'd plug those amounts into his into the SSI calculation to figure out how much SSI he should get. But I figured rather than looking at the variables about, well, how many payments did he get in this month? I figured it was easier to just say, let's look at on average how much he should get. Does that make sense?
Yes.
Okay, great. Yeah, so if you take the $50 a week reduced earnings payments, take $50, multiply by 4 1/3, you end up getting $416.67. And I just rounded it to 417. I'm sorry, $216.67. And I rounded it to 217. Right. So most popular answer was $77, which is correct. And then on average, what will his total monthly income amount be? You'd add the 1625 a month average gross wages, the 217 a month average reduced earnings or workers' comp benefit, plus the $77 a month average SSI, and the total would be $1,919 a month. Great. Very good. Any questions about that? The math gets a little more complicated if you don't have an SSI calculator. But I know I did distribute those during an earlier training. I think it was the one on Medicaid. So now let's talk about the interaction between workers' comp, cash benefits, and SSDI. So this is different and less beneficial than the interaction between unemployment insurance and SSDI. Those of you who remember that will remember that unemployment insurance and SSDI have no impact on each other. You can get the full amount of both benefits at the same time. Not so with workers' compensation benefits. Workers' compensation benefits will reduce SSDI benefits. So if a worker is getting SSDI based on their own work history and they start getting workers' compensation payments, their SSDI payments will be reduced. To calculate the exact amount of the reduction can be complicated. It may require you to get information that you're not readily able to get, particularly from Social Security. So rather than give you the formula for calculating the precise amount of the reduction in the SSDI benefit, what I'm giving you here is the maximum amount that the SSDI would be reduced by. Okay. So the reduction of the SSDI payment is never going to be more than the workers' compensation benefit amount. And in some cases, it may be less. So this means that the worker will never have less money getting workers' comp and a reduced SSDI benefit than they would get if they had only SSDI and didn't get the workers' comp. Okay. Okay. Marcia, I think if you've got the SSI calculator, um, that would make that last exercise pretty easy. It's not too complicated. The complicated part, I think the most complicated part is remembering that workers' comp is paid weekly rather than monthly. And if you're looking at the impact of workers' comp on SSI, you have to convert the weekly amounts into monthly ones. That's the most complicated part. If you have an SSI calculator, then you just take the monthly amounts and plug them into the SSI calculator. Pamela asks, does it reduce Social Security retirement benefits? No, it does not. That's a good question, Pamela. Social Security retirement benefits will not be reduced. Maricela says it would be helpful to have cheat sheets. Uh, yes, I apologize for not having a cheat sheet for this one. Um, but uh, but the PowerPoint is not excessively long and it's not hard to look up information in the PowerPoint slides. So suppose a worker's getting SSDI and they've got dependents who are getting benefits on their record, often referred to as auxiliary benefits. If the worker getting SSDI on their own record starts getting workers' compensation, we know there's a reduction in the Social Security benefit. The auxiliary benefits, the dependents benefits, will be reduced first. And if the reduction needs to be more than the total dependents benefits, and the dependents benefits will be reduced to zero, and then the rest of the reduction will be applied to the worker's SSDI. Okay. So it's kind of like that, when you're on the plane and they tell you, put the oxygen mask on yourself first before your kids. That's kind of the same logic here, I think. Now, if a worker does have a settlement, they get a lump sum payment rather than weekly benefits, then what you have to do is find out what period of time that settlement is meant to cover. How many weeks would that settlement amount have represented? And then you take, so if it's a settlement of $50,000 and it's determined that that ordinarily would have been paid out over 50 weeks, you take $50,000 divided by 50 weeks, that's 1,000 a week. Convert that to a monthly amount, and then that would be the amount that you'd use to figure out the maximum reduction in the SSDI. Okay, so it's the prorated monthly amount that you use to determine the maximum monthly reduction for the SSDI. Okay. Okay. Let's see some questions. Oh, good question, Lisa Marie. So if somebody is getting workers' comp and SSDI, their SSDI will be reduced. What happens if their SSDI is then converted to Social Security retirement? It's a great question. So when somebody gets SSDI and they reach their full retirement age, the SSDI is automatically converted to Social Security retirement. And that's a good thing because uh, their retirement benefit will be the same as their full unreduced SSDI benefit. And they'll no longer have an earnings limit, no SGA limit. They can earn as much as they want and keep their full retirement benefit. And there will be no longer any medical reviews once they get Social Security retirement. Now, one clarification, full retirement age is no longer 65. It was at one time. Then it went up to 66 for people born between 1942 and 1954. their full retirement age was 66 years even. For people born between 1955 and 1959, their full retirement age is somewhere between 66 and 67. And for people who were born in 1960 or later, their full retirement age is 67 years even. So if somebody was born in 1960 or later and they are getting SSDI when they turn 67, their SSDI will be converted to Social Security retirement. Now, if they're getting workers' compensation at that point, when their SSDI is converted to Social Security retirement, their benefit will no longer be reduced. The SSDI would have been reduced while they were still getting it. Workers' comp would reduce the SSDI. Once SSDI converts to Social Security retirement, there's no longer a reduction. That means their income will go up. Their Social Security retirement benefit will be the full amount rather than the reduced SSDI benefit. So switching to that Social Security retirement benefit for somebody getting workers' comp means their Social Security benefit amount will increase. Michael asks, how is the SSDI reduced math-wise? SGA would be triggered. Um, well, the actual amount of the SSDI reduction depends on the average gross wages that Social Security based the SSDI payment on, and that can be difficult to uh, to to find, Michael, or to get from Social Security. Um, so I just decided to simplify this and say that the SSDI would never be reduced by more than the workers' comp benefit amount. But in some cases, the reduction may be a little less than the workers' comp benefit amount, in which case the worker would come out ahead. Their their SSDI would be reduced by less than their workers' comp, and that means their SSDI, their reduced SSDI plus their workers' comp would actually be a little more than their original full SSDI amount. John asks, does the Workers' Compensation Board notify Social Security of payments to beneficiaries? I've dealt with some very large alleged overpayments from Social Security due to workers' compensation payments. Um, that's a great question. I am not sure if the New York Workers' Compensation Board notifies Social Security. So, if somebody is receiving SSDI based on their own work history and they start getting workers' compensation, they should definitely report the workers' compensation benefit to Social Security to avoid a big overpayment. So that's a great point, John. Um, and let's see, do I want to say something else about that? Oh, yes. If somebody is getting a form of Social Security disability that is not based on their own work history, like a childhood disability benefit, also known as disabled adult child benefit, or a disabled widows or widowers benefit, that benefit will not be reduced by workers' comp. It's only SSDI based on the worker's own work history that's reduced by the workers' comp. Okay. Oh, thank you for that link, Maria, on transitioning from Social Security disability to, or SSDI to Social Security retirement. Yes. So workers' comp benefits should be reported if the worker is getting SSI because they're unearned income and it will definitely reduce the SSI. And they should be reported if the worker is getting SSDI on the worker's own record. Absolutely. Thank you for reiterating reiterating that, Christopher. So let's do an example. This is, oops, going backwards. Okay, so Veronica got $1,500 a month of SSDI and was working, was injured at work. She's single, has no dependents. She's not yet getting Medicare. And she's approved for workers' compensation, gets temporary total disability benefits of $325 a week or $1,408 a month on average. What is the lowest amount of SSDI she should get after the SSDI is reduced? And then what will the lowest amount of her total income be? So remember, the rule is the SSDI is never reduced by more than the workers' comp benefit amount. And that should tell you how to figure out the lowest amount of SSDI she should get after the reduction. And then you'll just simply add the workers' comp of 1408 plus the reduced SSDI benefit amount to come up with your answer. And we are nearly at 11 o'clock. So I'm just going to go ahead and give you the answer here. Pretty easy. $92 a month would be the lowest amount of SSDI you'd expect her to get. And then the lowest amount of total income would be $1,500 a month. In other words, the same as the original unreduced SSDI benefit amount. So earnings should be reported whenever a worker getting workers' comp returns to work. They need to report that to the workers' comp insurer, or if the employer is providing their own self-insured workers' comp, and report it to the employer. Decisions by workers' compensation judges on workers' compensation claims can be appealed within 30 days. And then for more information, there's a Workers' Compensation Board website, an injured workers toolkit. There are various publications for workers. There are webinars, really informative stuff, upcoming and recorded webinars, and all of that is available online. So we are at 11 o'clock, and I just wanted to thank you all for participating in these trainings. Some of them have been rather intense. I did make a decision based on my experience in other states to have these trainings err on the side of perhaps too much information rather than not enough. Because I've found that people who participate in these state-specific benefit trainings regularly tell me they regularly go back to the PowerPoints and other information as references to look stuff up. And when you want to go back and look it up, if the detail that you need is missing, you're going to be disappointed and possibly mad at me. I use them for the same purpose. I don't memorize all of this stuff. I go back and I look them up. So that's why they're there. But please do try this at home. Do use this for people that you're serving. Use the HUD and SNAP calculators to estimate impacts of different levels of earnings on benefits people get. Use the other materials Cornell and VCU will tell you you need to learn the state specific rules about benefits in your state in order to do benefits counseling effectively. Now you've got that information. So thank you all for participating. I will be sending a recording to everyone after this. And best of luck in your future work advising.
Michael,
Yes, Pamela.
excuse me, I'm sorry. Are we supposed to be getting certificates for CEUs?
You can get CEUs from Cornell. Just request them from Ray Sabula. He
Oh,
honored CEUs for all of these trainings. If you work for a WIPA project and you've been certified by VCU, of course, then VCU can provide CEU credits for these trainings, but you need to request them from them. It's I don't know that it's guaranteed, but Cornell will definitely give you CEUs. If you have been certified by VCU as a community partner work incentive counselor rather than a CWIC, in other words, if you were certified by VCU, but you're not working for the WIPA project, unfortunately, you can only use VCU trainings for CEUs and not any outside trainings.
how do we know how many CEUs? Is it based on the hour?
It's
That
going to be
because usually you get a certificate, but
it's going to be based on the hours. And
okay.
yeah, and Ray already knows he already received the agenda, the menu of trainings and how many hours each uh, applied to. And so if you just simply look at the schedule for each of these trainings, how long they were scheduled for, and report that number of hours and the name of each training to Ray Sabula, he'll give you that number of CEUs.
Okay, great. Thanks a lot, Michael.
You're welcome. Any other questions, comments? Okay. All right. Thank you all again for attending. I will stick around just in case there are any final questions or comments, but I'm going to stop the recording and thank you again.